Okay, merci. And yeah, sorry, Ibrahim, you can keep on.
All right, thank you so much. So, like I said earlier, the complaint was filed against Niger Republic as a challenge to the enactment of Law 36 of 2015, and then second, against the way it is implemented and how the implementation has affected the lives of many people, particularly migrants, who are at the same time, in most cases, citizens of West African countries, who by the provisions of, the free movement laws of ECOWAS have the right to move, within all the West African countries, that is within the ECOWAS area. We know over the years, about 2 years, for 2 years now, we've been studying, the law and its effects, together with Alain Fonsara, and also the help, particularly from our colleagues in Europe and also in West Africa, particularly in Mali and Niger. And we came up with this idea of filing this complaint before the ECOWAS court to seek from the court, orders relating to the indictment of Niger Republic for violation of the rights of these migrants that are moving and who are subjected to many forms of abuses, including detention, expulsion, pushback, inhuman treatment, violations of so many rights that are documented, both by the interviews conducted, especially by Dr. Azizu and his team, and also other violations that were documented by international organizations that have made research, into the effect of this law. So this was actually what prompted the action, and that is basically what is pending before the court. And specifically, we are asking the court, to declare that the enactment and the implementation of the law has, violated the obligations of Niger Republic and both the ECOWAS and other international instruments, particularly relating to human rights that Niger is a member or is a signatory to. And then we also ask for specific declaration or order of the court, directing Niger Republic to review at the same time, review those provisions of the law, that offend international law and that are used, to violate. I can hear you. I have no idea what you're saying, Fiona.
No, she's translating.
Oh.
Yeah. Break, she's saying. Okay. Maybe it's too fast. I don't know.
I'm actually trying extremely to be slow, so I don't know. Okay, I can continue.
Okay. Unfortunately, Fiona cannot speak in the whole. Okay. She cannot speak in the main room as she's now the interpreter. Okay, it's just a communication between her and Hassan.
Oh.
Okay, they are fine. You can continue. Sorry.
Okay, so I can continue.
Yes, you can continue. Thank you.
Good, thank you. So basically, those are the prayers we have before the court. And as you know, there are two stages or two steps in the procedure of the ECOWAS court. These are one, the written procedure. And the written procedure involves you filing your documents in form of a complaint before the court with your evidence and also the basis, that is the grounds on which you are seeking the court to intervene. After you do that, then, you know, the respondents, that is the country or the person you are, you know, suing before the court, will now be given the opportunity to give their reaction in form of a response. And that has been done by Niger Republic, you know, where they denied everything, basically, that this is a law which, as a sovereign country, they have the power to enact, and that they did not in any way during the implementation of this law violate anybody's rights. At the same time, also, they said that the association, that is the DNSDD, and also the Malian Association of Deportees, who are the parties, that is the applicants before the court, they claim that they do not have the power to file the to file the complaint. So there is a number of issues to which we also have responded, because by the rules of the court, we have the right to respond. So we have responded to that. That was the state at which we were when we had the conference. We were expecting, if there is any further rejoinder from the Niger Republic, we were expecting to receive that, after which we are supposed to go directly into the second procedure, which is the oral procedure, where you know, the court would serve us with what is called hearing notice to come and present oral arguments, you know, on all the issues, and if possible, call witnesses. Now, if you recall, at the last conference, this was what we presented. And we also stated that we needed to hear firsthand from people that were, you know, on the field, who had interaction with victims or who themselves are victims of the implementation of this law. Unfortunately, we were able to meet many of these people who have shared very vital and significant information with us that we intend to use, particularly, you know, during the oral procedure. To date, as far as I know, we have not received anything from Niger Republic in terms of rejoinder. And the time, you know, set by the law of the ECOWAS court for the filing of such rejoinder has passed, which means what we should expect next is a hearing notice where, you know, for the oral hearing, where we'll go before the court and present, you know, our argument. So basically, that is what we are gearing up, you know, for right now, because the time for Niger to file any rejoinder, you know, to our reaction to their response has already passed. So what remains is the oral procedure, where we adopt our application and, if possible, make oral arguments, and then now give the court, you know, the opportunity to study everything, and then, you know, give us, you know, their own position on our application. I don't know if Bashir is around. Okay, I can see Bashir. Bashir, please, if you can take over from me to, you know, shed some lights on the current position of things, particularly since you are the one who is constantly in touch with the registry of the ECOWAS court, if you can share with us the new development we have, since the last conference in Niamey, it will be very helpful, to steer the discussion. Thank you.
Thank you very much, everyone. You have almost captured everything. That is the current position of our application before the ECOWAS courts. The only important point I want to add is that the position we are now is the point of the president of the court to appoint a judge rapporteur. And the function of the judge rapporteur is to give recommendations after studying the application and the response by the Niger Republic. The judge rapporteur is to recommend to the court what he thinks or he feels is the best way to go about the case. So that point is more of administrative activities involving the internal administration of the court, because the judge rapporteur will be appointed by the president of the court without involvement of the parties in the application or the complaint. So, and the judge rapporteur will carry his own assignment of studying and recommending a proper way to go about the case without involving us. It is after the recommendation, then the court will now inform us that this is what they think, best way to go about the application. And in such a situation, the court will inform us of whether we are going to embark on oral hearing of the application, whether there is need for us to bring oral witnesses that will be taken orally by the court, and also whether the court is going to start with the preliminary objection that was raised by the Niger Republic, as rightly highlighted by Mokhtar. So the judge rapporteur has different ways or different approaches that he may recommend to the court to go by one or two of the approaches that can save time, save resources, and also make it easy for the courts, with particular reference to the nature of the application and also the parties involved and the position of the law regarding that. So as we have stated earlier, the Niger Republic was supposed to have filed their own rejoinder to our own reply to their preliminary objection, and also our own reply to their defense. And so far they have not done that, which means they have waived their own right to do that, because if they had wanted to do that, we would have been served or given a kind of application for extension of time if they had actually wanted to do it, but they were out of the 30 days given to them by the courts or by the rules of the court. They have the right to come and apply for extension of time for them to do that. And up to now, for over 3 months, they have not done that. We can conclude with certainty that they don't have any rejoinder to our reply to their defense and also our reply to their preliminary objection. So we are now waiting for the recommendations and the report of the judge rapporteur, which will now be communicated to us to enable us to proceed to the hearing of the application. And it is after hearing is concluded, then the court will now take time or take a date to write its own judgment, which is the final stage of the application. So I think so far this is the position of the complaint before the CEDEAO court. Thank you very much for listening.
Okay, thank you very much. Je dis, je parle en français. Donc, merci beaucoup les avocats pour nous éclairer sur l'évolution de la procédure. En tout cas, merci. Pour ma part, j'ai eu des nouvelles compréhensions sur le développement. Mais avant de continuer, je ne sais pas si dans l'audience, on va passer directement à des questionnaires. Si des gens voudraient savoir de plus, en tout cas sur les exposés riches que les avocats nous ont donnés, est-ce que des gens voudront demander plus d'éclaircissement ou plus de détails? Je rappelle que sur l'application, on peut toujours lever la main. Au niveau de... C'est possible, non? Oui, OK. Léonie?
Merci. Je vais aussi parler en français. Oui, merci beaucoup pour la présentation. Oui, et cette information commence à se développer les derniers mois. Peut-être vous avez dit ça, mais je n'ai pas encore compris. Comment est-ce que cette recommandation sera faite par le cours des COVAS? Alors, à quel moment, dans quel mois, dans quelle semaine est-ce que cette décision ou cette recommandation sera prise? Je n'ai pas bien compris. Est-ce que vous avez des idées sur ça? Et une autre question, est-ce que vous avez encore besoin du soutien de la société civile et si oui, lequel? Merci.
Merci Léonie pour les questions. Peut-être un des avocats peut donner des réponses, Ibrahim ou Bachir.
Okay, I can answer the first question and then, the second question, and Bashir answer the first. Yes, the question regarding support, definitely we need support from civil society. One of the things that, you can do as part of our discussion, especially at the level of the think tank, we mooted the idea of maybe getting some international organizations, maybe to file what is called amicus brief. That is as an interested party, someone who has been studying this and who also feels that, you have, the obligation to intervene. You can actually go before the court and seek, as a friend of the court, to give your own perspective, of the application. If you have some information that can help the court to, to reach a just and fair decision, you can actually do that. That is at the level of, going before the court directly as an amicus, as a friend of the court, just to help, not as an interested party, but as an amicus. You can file an amicus brief. This is in the procedure of the court. That's number one. Number two, if you have any information, you already know what we have before the court. If you have any information that can help us, or if maybe you're a lawyer and you have studied the law, you have some precedent, some decision relating to this, that can help the court reach fair decision, you can actually, help us with that, because that can help us also in the oral presentation. So, and there are many other things that may come up, maybe later. We don't know what recommendations the judge advocate would give. probably there may be possibility of asking for maybe witnesses. And I believe that you can help us with this as persons who have actively been involved, in this situation. So the information that you have, and also the persons that you know that are directly affected by the effect of this law, maybe potential witnesses, if there is need for witnesses, maybe potential witnesses that we can use to, support, the claim that is already before the court. Lastly, and I think I raised this issue with some colleagues at the last conference in Niamey. I think there's also the possibility, aside this, there is also the possibility of filing another case directly, maybe by victims. The case we filed was not filed directly by the victims themselves. It was filed by organizations and public, interest litigation. It is a litigation in the public interest that we filed before the court. But you can have, if you have individuals who suffer violation as a result of the implementation of this law, probably maybe within your network, we can use this individual to also, challenge the law and at the same time seek some reparation against Niger Republic. So these are the three ways in which I think you can intervene. Thank you so much. Bashir, over to you on the first question or recommendation.
Okay, thank you very much for allowing me to be back here. Well, as to the recommendations, it is the president of the court that appoints the judge rapporteur, and the president gives the judge rapporteur terms of references, which will include the time frame, the period within which the judge rapporteur is to conclude his own findings on the case, and also to submit his report to the president. And that is done administratively. It is not something that is done in the open court or involving the parties in the case. We, however, have the right to know the report once the report is out. And the rules of the court has given the judge rapporteur a guideline on how to carry out his job and what type of recommendations are expected. So the recommendations that may come from the judge rapporteur can include a recommendation for bringing expert witnesses or getting expert opinions from other independent sources. As Mukhtar said, the court may require some expert like friends of the court, amicus curiae, and the recommendation can also include need to bring oral witnesses, because our case we file here, we file based on affidavit evidence. We file the position of the witnesses, that is the evidence of the witnesses were written and signed by the witnesses out of the court, not before the court. So if the court feels that the nature of allegation against the Niger Republic requires that an expert opinion should be given from independent source, and also there is need to get oral hearing, the court can say we should present our oral witnesses. But with the nature of this, we cannot actually say with confidence that there may be need to present oral witnesses, because it's an application that we are asking for interpretation of the legality or otherwise of Law 36 of 2015. So we are basically challenging the legality and implementation of the law by extension. So we have more confidence that it is going to be concluded without the need to bring witnesses to be taken orally. And also the recommendations will include an advice. The recommendation is by way of like advising the court by the judge rapporteur to state to the court that based on my own analysis and study of this case, the court should go ahead and take steps A, B, and C, which I think is the best way to expeditiously conclude this case in the best interest of justice. So that is in a way fast-tracking approach to fast-track and summarize all the claims and the evidence so that the court will not have to start everything afresh. And it also can include the recommendation of reliefs. That is what the court ought to do at the end of the day. But that is not a final hearing. It's just like a preliminary inquiry to come out with recommendations of the best plan to go about the case. And I hope that may have answered the question. Thank you.
Okay. Merci beaucoup, Mokhtar et puis Bachir. Je pense que Léonie, ta question a été répondue. Je vois il y a la main de Saliou qui est en haut. Si tu veux intervenir, Saliou. Ah non, c'est EBS, ok. Ok. D'accord. Ok, EBS. Mais avant, je voudrais dire quelque chose pour nos chers camarades traducteurs, traductrices, parce que je pense que vous êtes aussi des camarades de la lutte dans un certain niveau aussi. Donc, je pense que ne pas seulement se limiter à la traduction, si ça se trouve intéressant et que vous avez des questions, même si dans le chat, vous pouvez participer parce que, voilà, je pense que vous êtes sur les mêmes luttes aussi que nous. Donc, voilà, ce que je voulais ajouter. Merci. OK. Salut, Ebs.
OK. Salut, c'est parce qu'un de nos enfants utilise le Zoom aussi pour l'école à cause de ça. OK. Bon. De toute façon, merci de ma part aussi pour la présentation de la part de Bachir et de Mokhtar. Concernant la côté de témoignage, je voulais dire que de toute façon, je trouve ça quand même un côté très intéressant pour APS de même si on ne sait pas si la Cour va demander des autres témoignages oraux, il sera quand même intéressant de déjà commencer à chercher des témoins potentiels aussi au cas que on veut faire, à part de la plainte qui a déjà été déposée, des plaintes individuelles, comme c'était dit que des victimes de l'application de cette loi peuvent aussi faire des plaintes individuelles. Alors, des témoins potentiels peuvent peut-être aussi être des porteurs ou porteuses de plaintes individuelles. Je pense que ça serait une tâche intéressante pour nos groupes locaux, pour nos lanceurs et lanceuses d'alerte, d'alarme Front Sahara, de chercher où il peut y avoir des personnes qui peuvent être des témoins ou des porteuses de plaintes individuelles. Je pense quand même dans la région d'Agadez, il y a plein de telles personnes potentielles. Et je voulais dire, là, il serait aussi intéressant peut-être si on pourrait, en même temps, si des gens, si des témoins qui sont eux-mêmes des victimes de l'application de cette loi, si eux et elles sont prêtes à ça. Il serait aussi intéressant de combiner la stratégie juridique avec d'accompagner ça avec du travail de visibilité à notre part. S'il y a par exemple des témoignages qu'on peut publier à notre niveau, soit ça sur le site de APS ou soit ça dans des différents médias au niveau du Niger et au niveau international. Je trouverais ça aussi intéressant. Okay, ça, proposition de ma part pour ça. Et en même temps, j'ai une question encore à propos de la continuation de la plainte d'un part. Si finalement la cour de la CEDEAO va faire une décision, va juger l'État du Niger, quelle sera la conséquence de ça pour l'État du Niger. Et surtout dans ce sens, je voulais demander parce que l'État du Niger, à son niveau, est dans une procédure de révision de la loi 2015-036 et de quelle manière le résultat de cette révision pourrait être influencé par le résultat de la plainte, ce que pourrait être une bonne chose. OK. J'ai fini de ma part. Merci.
Okay. Merci, Ebs. Est-ce qu'il y a d'autres questions? Oui. OK, il y a Dorette.
Oui. OK, je peux aussi parler en français. Je voulais demander par rapport aux témoins qui peut-être vont être nécessaires, même si peut-être non, comme j'ai compris. Est-ce que c'est possible de maintenant amener d'autres témoins que ceux qui ont répondu en cours de la plainte, ce que avec les témoignages que APS a mis qui sont dans la plainte, mais est-ce que maintenant ce serait possible de maintenant encore amener dans cette plainte encore autres individus, ou ça devrait être les individus qui étaient nommés, qui ont donné leur témoignage dans la plainte, ou oui, c'est compréhensible. Oui, je voulais savoir ça parce que en fait, une nouvelle plainte quand même, c'est aussi encore une grande chose, aussi financièrement, ou je sais pas. Quand même, c'est à réfléchir, je pense, mais ce serait quand même aussi intéressant, si possible, si c'est demandé d'amener d'autres témoins dans la plainte en cours. Mais si ce n'est pas possible, OK.
Je ne sais pas si la question a été bien comprise par les avocats. Good. D'accord. Donc, pour ma part aussi, c'est une des questions, mais Epps l'a déjà touché. C'était de savoir que l'État du Niger est sur la révision de cette loi. Depuis, on en avait parlé pendant la conférence et jusqu'à aujourd'hui. Si cela pourrait changer quelque chose de la décision du juge, du président de juge qui va donner l'ordre au président, au juge rapporteur. Est-ce que cela pourrait changer quelque chose? Parce que si l'État du Niger a déjà dépassé le délai de réponse au niveau de la cour et qu'à ce niveau, il n'y a pas eu d'appel, est-ce qu'ils ne pourront pas utiliser cet argument de révision de la loi pour demander, je ne sais pas, un report ou bien en tout cas avoir un argument sur le fait que ça peut changer le cours de la procédure. Donc voilà quelque part un peu ma question donc, qui rejoint celle de EPS et aussi celle de Dorette a posé une question. Donc si les Ibrahim Mokhtar ou Bachir Sabiou pourraient, et c'est très dommage parce que à chaque fois on dit une conférence, mais ça devient un peu un interrogatoire pour les avocats, mais c'est pour les spécialistes de la chose. Oui, oui. Donc, si vous pouvez nous donner plus d'éclaircissements.
All right, thank you so much. The question by Epps, the first part of this intervention is more like observation, on some of the points made. But at the tail end of his intervention, he asked a question about what the effect of the review would be on the decision of the court and how would the decision of the court probably influence action by Niger Republic. First of all, it's important for us to understand that ECOWAS court is a regional court. As an international court or as a regional court, it has the power to examine actions of states, particularly as it relates to its obligation under international law, under the regional law. And also it has the power to make orders that are binding on Niger Republic. I started with this because this debate about how judgments of international tribunals, how enforceable, directly are those judgments is one of the problems of international law generally. The court has the power to make the orders. The court has the power to make findings. The court has the power to tell Niger Republic to stop this or that action. Now, the problem is whether Niger Republic will comply. Whether Niger Republic will comply, with the decision. That we actually don't know. That we don't know. We don't know because one of the issues that are currently facing the court as a regional court is that there are many of its decisions, that the states, refuse to comply with. We have a number of decisions in Nigeria, particularly where the court found Nigeria wanting, where the court found Nigeria liable for violation of rights, where orders were made, directing Nigeria, for example, to release certain individuals from detention. And, you find that the government would not comply with those judgments. I think I read about a year or so ago that the president of the court complained bitterly about this. But one thing that is very clear is that whether or not Niger Republic complies with the judgment of the court, it remains a binding judgment. It is an indictment by a court, by an international court, that Niger has violated the rights of this individual. It's also an indictment of anybody within Africa or outside it that is working with Niger Republic or helping Niger Republic in any way in implementing this law. So we do not have the power to force Niger Republic to comply with the judgment, but we have the power to force Niger Republic to come before the court.
Mais on a le pouvoir de mettre le Niger devant la cour.
On the action of Niger Republic. And once that is done, it becomes binding. International law remains
Et là
binding.
aussi, ça devient des décisions qui doivent être respectées, légalement dit. J'espère que j'ai pu répondre à la question comme ça. La deuxième partie de la question, si
I don't know, we tried at the last conference to explain that one of the issues raised by Niger Republic is that it is within their powers as a sovereign state, to do that. In fact, they are saying they are even under obligation, particularly under the Palermo, convention protocol, to make that law. And we are saying no, it is not. This is a textbook example of a law criminalizing migration, a law criminalizing solidarity with migrants. This is a textbook example of that. And the law has in many ways violated Niger's obligation under international human rights law. So the process of the review of this law started as a result of these pressures by civil society, we understand, and also other international organizations on the effect of this law. And this case is one of those, we understand, pressures that is being mounted on Niger Republic. So I'm sure Niger will do well to take into consideration some of the issues we raised while, undertaking a review of the law for potential consequences of that particular action that is currently pending before the court. Lastly, and I think this is important, whether the review itself can affect the judgment of the court, the eventual judgment of the court. The answer to this is no. What we are, you see, the law has already been passed. The allegations we made against the law have already happened. The violations have happened. So an action by Niger Republic now reviewing the law will not change the fact that rights of individuals have been violated using the law that they are currently reviewing. So whatever review they make will only affect future action and behavior, but it will not affect what has already happened in the past. So the court would only work with what has been presented before it, which is Law 36 as it is now, coupled, we know, with facts showing that the implementation of this law has been done in such a way that violates the rights of individuals. So the court will make its finding based on this. It will not take into consideration the fact that the law is being reviewed. This will not affect, the judgment of the court in terms of finding that the law itself or its implementation has violated the rights of migrants. This is my humble opinion. I don't know if Bashir has anything to add on this.
Well, thank you very much. I think what you have said is also my own opinion. The review of the law will not affect the decision of the court because the court is doing its adjudication based on what has already happened. That is, it takes place.
La cour fait ses jugements sur ce qui a déjà été réalisé et pas en ce qui concerne ce qui va se passer.
While the decision of the court will look at what has already been done and to base its own decision on that. Even if the law is now reviewed and the court comes with a decision that that law is illegal and it is against human rights protocols or treaties, signed by Niger Republic, that will add additional impetus or additional force to the review or to the new amendment of the law. So we are asking the court to make pronouncements to say that the action of the Niger Republic is illegal. So their own review of the law cannot preempt the decision of the court. Yes, that is my own understanding of that. As regarding the review of the law.
Sorry, Bashir, there is this question about Britain. Well, I don't know if you can respond to that, whether we can add witnesses at this stage or it's not possible. I think it's important you respond.
Yes, at this point, we have already closed our exchange of court processes. That is, all our documents that we needed to file before the court have already been filed. There is a time limit for each of the steps taken before the court so far. So as it is now, there is no room for bringing additional witnesses. However, if after the recommendation by the judge rapporteur of the steps to take, the court may see need to get more evidence. In that situation, we can be asked to bring more witnesses. But in my opinion, what Mokhtar has said is the best way to go about getting more witnesses is by filing a fresh suit by victims themselves. People who were directly affected by the implementation of this law, to come and give oral testimony before the court, for the court to see them and ask them questions to hear directly from them. People who have witnessed it, as I said previously, our own evidence before the court is based on affidavits, based on written deposition by witnesses of the violation of the human rights going on there, and by some victims of the violation. It was put in writing, but the nature of the application before the court does not call directly for presenting witnesses orally. The court is to rely on the written evidence of the witnesses and reach a decision. But when it is a case filed by the victims themselves, telling the court that I was my right was violated and I suffered violation as a result of implementation of this law, that will give the court opportunity to hear directly from the witness and also make findings to the extent of even awarding damages in form of monetary compensation to the victims, because the victims appear before the court and convince the court that their human rights has indeed been violated by the Niger Republic. But in our own case, we are not asking for damages against the Niger Republic. We are only asking for interpretation of the court to pronounce and make the law and the implementation of the law illegal. So the best platform to bring witnesses will be a case of victims filing personally in their own personal names. But so far, in my opinion, the evidence we have produced before the court now can suffice for the court to go ahead and adjudicate the logical conclusion of our complaint. Thank you very much.
Thank you very much also, the lawyers, for this clarification that you give us. Oui, je disais merci pour les éclaircissements. Et il ressort que, en fait, au-delà du travail que les avocats sont en train de faire, une bonne partie est pour nous, la société civile, donc de supporter, d'aider à avoir peut-être de nouvelles informations et aussi voilà, d'informer beaucoup plus et de cueillir plus de témoignages de violations de droits humains sur les migrants. Et chers participants, on a nos vaillants et vaillantes traducteurs qui vont nous lâcher dans les 8 minutes à venir, ou bien des traducteurs et traductrices vont nous lâcher, vont partir. C'est déjà beaucoup trop. Merci beaucoup pour ce qu'ils ont fait. Et avant de continuer, ou je ne sais pas quelle est la motivation des gens et quelle est la possibilité pour nous de continuer. Est-ce que les gens voudront continuer plus ou bien on doit arrêter à partir de 30 parce que c'est l'heure où les deux traductrices et traducteurs vont partir. Et si les gens voudront rester aussi encore un peu plus longtemps, ça va devoir trouver des solutions ou une solution alternative pour continuer. Qu'est-ce que vous en pensez? Léonie?
Je voulais juste mentionner que Ibrahim et Bachir, vous avez aussi dit que vous devez quitter à un certain moment, je ne sais pas à quelle heure, mais il faut aussi considérer le temps les capacités des avocats aussi. Oui, c'est ça que je voulais dire. Vous pouvez dire un mot à quelle heure vous voulez partir. Ça dépend, je vois plutôt aussi de vous.
Bachir et Mokhtar? How much time do you have?
Yeah, if we are done from our own end, we may take our leave.
Okay.
I don't know whether he intends to stay longer.
I don't know. So I really don't know if there's any further issues to discuss that maybe require our participation. If we can know what other items you have, if there's need to stay, I can just take maybe a few minutes break and then I can rejoin. But if there's nothing for me to add, I can leave altogether. Thank you.
OK. Bon, ce que je trouve, c'est qu'il n'est pas peut-être nécessaire de reprolonger parce que les questions ont été posées et je pense qu'on a eu assez d'informations et d'éclaircissements sur le développement de la situation et aussi de ce qui est des demandes des avocats pour ce qui est de notre support, ce que nous pouvons faire. Et on sait à partir de là maintenant aussi qu'une bonne partie est au niveau de la cour, c'est-à-dire c'est en attente qu'eux-mêmes aient des informations. Il faudrait que le juge et le président du tribunal nomment un juge rapporteur qui va faire des recommandations. Donc, c'est carrément en attente. Mais aussi, on sait de notre côté de la société civile que nous pouvons toujours appuyer par des informations ou bien des rassemblements de témoignages. Et une dernière peut-être question à l'endroit des avocats, parce que bon, peut-être au niveau de la traduction, c'était pas très bien clair pour les autres, peut-être même pour moi aussi, parce que c'est aussi les termes juridiques. Et là où ils ont parlé de amicose, c'est-à-dire des amis du tribunal ou bien de la cour qui peuvent venir. Je sais ce qu'on appelle une partie civile. C'est-à-dire, est-ce que ça veut dire que des gens peuvent se constituer en partie civile? Et si oui, quels sont les profils de ces personnes? C'est-à-dire, c'est seulement des gens qui ont des capacités juridiques ou bien qui sont des lawyers eux-mêmes ou bien des groupes d'avocats ou bien même ça peut être des civils. Donc, peut-être avant que les avocats nous quittent, j'aimerais poser cette question. Et enfin, il y a la main de Dorette et Eps. Comme cela, on pourrait...
Et Mokhtar.
Et Mokhtar Naloso. Parce qu'on n'a que 4 minutes pour les traductrices qui ont mentionné qu'elles doivent partir. Donc...
Il y a certains qui ont dit qu'ils peuvent rester un peu plus longtemps. et traductrice.
Oui, d'accord. OK, d'accord, on va faire comme ça. On peut essayer. Est-ce que les juges ont pris ma question? S'ils peuvent répondre, comme ça, on va prendre Eps, Dorette et Naloso. Non.
Yeah, the question is understood. I think Mokhtar should answer the question because he raised the issue of amicus curiae initially. Thank you.
Oh, okay. I think if I understand the question is about filing amicus brief. So the procedure of the ECOS Court allows for that. And in most of the cases, what you find is that this is a brief that is filed mostly by maybe organizations that have that are interested in the issues that are placed before the court. So they can file their own position regarding the questions that are submitted before the court in form of information that is available to them, and also back up by legal positions that they believe that should be the correct position regarding the issues that are before the court. So it's just about coming before the court and saying that as a friend of the court, I have this information and I have this legal position that I believe can help you in reaching a just decision. So mostly it's organizations that do that, but notwithstanding, a lawyer can also approach the court, to do the same. Amicus is just appearing before the court as a friend, because by saying that I want to be heard, not as a party, but as a person who is interested in justice. And I have this, submissions that I want to make before the court that can help the court reach, a just decision. So you find that in most cases, international organizations, human rights monitoring bodies, and so on, sometimes, appear as amicus, before the court to make this kind of submission so that the court can, look at it while trying to decide or to resolve the dispute between the parties.
En essayant de décider comment résoudre le conflit entre les parties. Donc, je ne sais pas si je peux répondre à votre question, mais je ne sais pas si j'ai tout capté de la question. Et je vous remercie.
Ok, juste un truc. Moi, que tu as dit, c'est confirmé, n'est-ce pas?
Non, j'ai répondu à l'avocat qui disait, il ne sait pas s'il a tout répondu. J'ai dit oui, s'il a bien répondu.
Ok, super. Juste un truc technique parce que c'est maintenant 12h30 ou c'est 30 maintenant. Lina, vous allez nous quitter. Merci beaucoup pour votre soutien.
Oui, est-ce que tout le monde peut les applaudir par là? Merci vraiment.
Merci vraiment. Oui, et je vais vous mettre Fiona maintenant à la place de faire la traduction de français en anglais comme elle a se proposer volontairement. Merci beaucoup pour cette soutien aussi.
Il y a Hassan Ould Mokhtar aussi qui est là pour l'instant.
Qui est là, oui, merci Hassan que tu vas continuer.
Il dit, ouais, merci pour l'instant.
Et ça doit être actualisé. Merci beaucoup.
OK. Il y a Dorette, non, il y a Eps, Dorette, Naloso.
OK. Merci. Moi, je voulais dire, en fait, oui, j'ai bien compris ce que les avocats ont dit, que la révision de la loi au Niger ne va pas changer la question de la décision de la Cour, comme la décision de la Cour se réfère à des actes qui ont déjà été faits. Ce côté, je comprends bien, mais d'autre part, en fait, je voulais bien savoir si, d'autre part, une décision de la Cour de la CEDEAO, de sa part, si elle peut influencer ce que vous tous pensez, de quelle manière une décision de la Cour de la CEDEAO pourrait influencer la procédure au niveau de l'État du Niger pour la révision de la loi 2015 036. S'il y a une décision de la Cour favorable à notre plainte, si ça peut jouer un rôle positif pour faire pression sur l'État du Niger de changer cette loi à fond pour abolir les pratiques qui violent les droits de migrants et migrantes, de citoyens et citoyennes du Niger.
C'est maintenant directement la deuxième question ou comment on fait? Octa, tu es muté.
Oui, je pense, oui, tu peux faire la deuxième question, la suite de la question, comme ça après ils vont répondre.
Ok, je reste aussi en français. Moi, je voulais juste savoir un cas que on avance dans cette idée de faire une deuxième plainte. Si vous, Bachir et Mokhtar, vous seriez aussi toujours prêts aussi de soutenir une deuxième plainte aussi. Bon, c'est toujours aussi la question les possibilités avec les questions de langue, mais bon, avec les Hausa, il n'y a aucun problème. Je vois juste parce que oui, si par exemple des personnes de Agadez ou par exemple des gens qui ont travaillé dans le transport des migrants, si, ça peut être des personnes comme ça aussi, non, des Nigériens. Comme les migrants eux-mêmes, ils sont très vulnérables. Je pense que c'est très, très compliqué que eux, ils vont faire une plainte, mais des citoyens nigériens, je pense peut-être là, on pourrait quand même réfléchir et c'était juste si vous seriez aussi prêts de vous impliquer. Fini.
Je continue. La troisième question, ou bien on attend qu'il réponde.
Peut-être que, je ne sais pas si les avocats, vous suivez les questions ou parce qu'il y a un peu trop de choses à la fois. Ou bien bon, c'est la dernière question. Qu'est-ce que vous préférez? Désolé vraiment.
Well, I think we should
Je pense qu'on doit répondre aux première et deuxième question.
OK. OK, d'accord, merci.
Maybe he will still have to repeat the answer again as to whether the decision of the court can influence action by the Niger Republic. I think maybe he has to recap the answer.
All right, thank you. I think I answered that question partly. Yes, of course, the decision of the court will influence the review that is currently going on Law 36. That is the whole idea of going to the ECOWAS court, actually, to get an order directing Niger Republic to review that law or to entirely, abolish, the law itself. That's basically why we went to court. So now it becomes where the court actually makes such a pronouncement, then it becomes an obligation. It becomes an obligation, not just a suggestion or some sort of pressure being mounted on Niger to review the law, but here it will now become an obligation on the law. On the country, on the government to change that particular law. So definitely it will influence. Secondly, on whether we'll be ready to help with second complaint. Of course, depending on the circumstance and also the kind of the case and whatever it takes, of course, we'll be ready. Only that maybe when we have the victims, or rather we have the cause of action that is to be presented, probably then we would have a discussion on the proper way to approach it. But on whether we are available and ready to assist as we did or as we are currently doing, of course we are. Yes, thank you.
Ok, merci. Naloso, tu peux continuer. Je pense que c'est bon, non, RC Dorette, pour les réponses. Cool. Donc, Naloso. Naloso, Moka.
Oui. Ok. Merci beaucoup. Moi, ce que j'aimerais, ma question c'est, maintenant, on a déposé une plainte contre l'État du Niger. Ils ont répondu, on a fait ceci, ils ont fait cela, ils sont maintenant à révision, mais c'est lent. C'est lent. Maintenant, si, par exemple, la CEDEAO, les pays membres de la CEDEAO, par exemple.
Pardon, pour la traduction, ça ne marche pas. Je crois que tu es dans un endroit où il y a du bruit. Est-ce que...
Non, juste... Ok.
Bien.
Ok. Maintenant, vous m'entendez?
Tu peux aller doucement aussi.
Toi. Vous m'entendez?
Oui, c'est bon.
D'accord. Je disais, nous avons déjà déposé une plainte contre le Niger. Ils ont répondu, on a fait ceci, ils ont fait cela, on a fait ceci, c'est lent. Le processus est lent. Maintenant, je demande aux avocats, si par exemple nous arrivons à faire un collectif d'associations des sociétés civiles sous-régionales, la CEDEAO par exemple, Burkina, Mali, Togo, etc., les différentes associations de la société civile, y compris nous faisons un collectif pour mettre le bâton dans les roues de la CEDEAO. Parce que la CEDEAO, puissante qu'elle prétend être, est consciente qu'une de ces lois a été violée au Niger. Parce qu'il y a une loi de la libre circulation qui a été violée au Niger. Ils sont conscients, mais tout le monde sait, parce que ça vient de l'Union européenne. Donc, si par exemple, chacun de ces pays, ici, il y a les sociétés civiles qui passent par exemple à la télé pour décrire ce qui se passe au Niger, est-ce que ça ne peut pas bouger les choses plus rapidement? Par exemple, nous trouvons des migrants, des victimes qui vont faire des témoignages clairs, nets, précis, des témoignages OK. Et de l'autre côté, un peu partout, les sociétés civiles parlent à la télévision, faire des interviews, tout ça là, pour parler de ce qui se passe au Niger. Est-ce que ça ne peut pas mettre le bâton dans les roues de la CEDEAO, y compris de l'autre côté, nos avocats sont là, ils vont nous appuyer. Est-ce que ça ne serait pas plus cool? Voilà, c'était ça ma question.
Would you like to take that?
Yes, I think you can.
Okay.
So let me take it.
Okay.
Very much. As the issue of language, in the last part of the question answered by Mukhtar, also touch about language, where the witnesses cannot speak the language of the court. By the rules and the protocols of the court, the language of the court is any of the languages spoken in the community, that is in the country or in the member states under the ECOWAS Treaty. So the language should not be a barrier where a person, a witness, or an expert cannot speak any of the official languages. The court will allow any language to be spoken, and an interpreter will be provided to interpret the language to any of the languages of the court. So language will not be a barrier so long as a party is interested or a witness is interested to give evidence before the court. A translator will be provided for that. And about the gathering of evidence, that will also help that any witness or any statement of victims, you are able to gather directly from the victims, and if the victims are ready, they are willing to be available to give that evidence before the court in whatever language they are able to. That will be a good development, and it will help the case to be filed if that is decided finally to be done. So any evidence, so long as it is from the victims or eyewitnesses, it is going to be helpful irrespective of in what language it is. It's a court of multilingual languages, so definitely there will be a room for interpretation or translation of any language to the understanding of the court. I believe language will not be a barrier to filing the case before the court. Thank you.
Sorry, I think the last question was about whether you can, gather victims, from different, countries of West Africa, to come together and kind of give maybe televised testimonies of what has happened to them, and whether that can actually help the case. Of course, I think, yes, it will help the case by probably exposing the position of things while the case is going on. I don't know about whether that can actually influence the decision of the court in any way, but it will bring to the public, what exactly is actually happening. And also it can lay probably some basis or foundation for exploring maybe further actions, against the Niger Republic, which could even be collective actions by these victims that we are talking about from different countries. It's part of the reasons why we use organizations from Niger and Mali, to show that this thing is happening in Niger, but it affects, the citizens of West Africa generally. And one of the objections actually that was raised by Niger was particularly against the association in Mali was that, the association in Mali does not have any presence in Niger, was not actually registered in Niger, and this is a law that is enacted for Niger Republic. And our response to that was that, of course, it's a law that is enacted in Niger, but it affects not only the citizens of Niger, but also other citizens of other countries within West Africa. So such collective action is very, very important. And if you can get that, I believe it can help a lot, both for the present action that is before the ECOWAS court, and equally for any other potential action that we may like to file later. Thank you.
Thank you very much. Merci. Je pense que s'il n'y a pas de questions, d'autres ou des contributions, on va devoir s'applaudir et se dire merci. Encore une fois, merci aux vaillants traducteurs, traductrices qui nous ont permis de continuer. Merci à toutes et tous qui ont été présents. Et surtout, merci à nos avocats qui, au-delà du travail qu'ils font sur le terrain, aussi donnent leur temps pour nous expliquer et nous donner toujours des éclaircissements pour la suite. Vraiment, merci. Nous sommes reconnaissants pour tout le monde et à toutes et tous. C'est une première, cette réunion continuelle en ligne, tout comme la conférence transnationale a été une première à Niamey. Cette conférence en ligne aussi est une première pour la suite. Donc, c'est que sûr, nous allons revenir avec plus d'amélioration, avec plus en tenant compte des suggestions des uns et des autres, en choisissant un bon temps qui va permettre à ce qu'on ait plus de participation. Donc, vraiment, merci et à tout moment. Ciao, ciao et bonne journée à toutes et tous.
Merci aussi pour la modération.
Merci, merci.
Bonne journée et merci.
Merci
Merci à tout le monde.
Merci à tout le monde.
Merci, merci à tout le monde. Merci pour la modération, merci pour la traduction, and thanks to the lawyers for highlighting.
Merci Léonie pour l'organisation spéciale. Merci.
Thank you.
Thank you. Merci à tous qui étaient présents pour les suggestions.
Yes,
merci.
Okay.
Thank you very much.
Merci pour la disponibilité de la salle.